a silent earthquake in the Constitution. While most Americans were glued to political headlines, courtroom drama, and culture wars, a quiet but powerful event unfolded inside the marble halls of the Supreme Court. In a rare moment of total agreement, the justices issued a 9-0 unanimous decision, not on a technicality or minor regulation, but on a fundamental question that strikes at the heart of personal freedom. This ruling doesn't shout about the Second Amendment, but if you carry a firearm, own one, or simply care about how far government force can go, this decision changes everything. The case Barnes versus Felix centered on a police shooting, but the court's opinion reached far beyond one tragedy. It redefined how the Fourth Amendment protects you from excessive force and unconstitutional seizures. And here's the critical twist. This wasn't just a correction, it was a complete rejection of the way lower courts have handled these cases for years. The ruling demands a new standard, a deeper one that considers the full context of an incident, not just the split second when a weapon is drawn. So why should gun owners care? Because this changes how every armed citizen might be treated in a traffic stop, during a home visit, or while simply exercising their rights. The rules of engagement have shifted and they now lean toward accountability. What the justices ruled and why it matters. How this affects self-defense cases and concealed carriers, and what every responsible gun owner must understand going forward. Let's break down this ruling step by step. The promise of Duncan versus Bonta. This wasn't just any lawsuit. Duncan v. Bonta was personal to millions of law-abiding gun owners in California. For years, they had lived under some of the harshest magazine restrictions in the country. And then came Judge Roger Benitez, who ruled that California's ban on so-called high-capacity magazines violated the Constitution. That ruling lit a fire nationwide. It seemed to validate what many already believed, that laws restricting magazines based on size or capacity weren't really about safety, but about control. Benitez said what many felt. The Second Amendment doesn't have a round limit, but that hope was short-lived. The Ninth Circuit reversed Benitez, claiming the ban served public safety, even if it meant infringing on a constitutional right. They said these magazines weren't historically necessary. They argued the government had a compelling reason, and that's when things collided with Bruen. Bruen changed everything, or did it? In New York State Rifle and Pistol Association versus Bruen, the Supreme Court laid down a new standard. No more balancing tests. No more government justifications about crime rates or feelings. If a gun law doesn't match the history and tradition of firearm regulation in this country, it's unconstitutional. Period. That's why Duncan became such a pivotal test. The Ninth Circuit's reasoning clashed directly with Bruen. Instead of looking at history, they looked at what lawmakers today think is reasonable. That's exactly what Bruen said courts can't do anymore. So Duncan's team went back to the Supreme Court, asking it to step in, once and for all. But instead of hearing the case or denying it outright, the Supreme Court quietly moved it, rescheduling the decision for later. No decision is still a decision. This silence, this delay, speaks volumes. When the highest court in the land doesn't act, the laws underneath don't pause. They stay in the books. People still get arrested, prosecutors still press charges, gun owners still lose their rights while waiting for a ruling that may never come. And this isn't new. We've seen this kind of strategic waiting before. In Ketanji versus Massachusetts, it took years for the court to say that even modern weapons like stun guns are protected by the Second Amendment. In the meantime, people were prosecuted and convicted for simply having a non-lethal device in their purses. What we're seeing now in Duncan feels familiar. A delayed decision that keeps everyone in a state of legal confusion. While SCOTUS waits, states push forward. Some states aren't waiting for clarity. They're pushing ahead with new restrictions. New Jersey, Oregon, and Colorado all introduced or enforced magazine bans that resemble or even exceed California's. Why? Because they know delays benefit them. The longer the court stays silent, the longer their laws stay enforceable even if unconstitutional. That creates a legal patchwork. One state says 15 rounds are legal, another says 10, a third says pre-ban magazines are fine, but only if you've registered them. For everyday citizens, this is chaos, not law. And if you get it wrong, you don't just get a fine, you get charged with a felony. The real-world cost of legal limbo. Think about this scenario. You bought a 17-round Glock mag during the brief window after Judge Benitez struck down the ban. You still have the receipt. You carry it unloaded in your glove box exactly as your instructor advised. Then you get pulled over, the officer sees the magazine, arrests you, and now you're facing a criminal charge even though what you did was legal when you bought it. This isn't fiction. This is what's happening in states like California and New Jersey right now. Because when courts send mixed signals, enforcement doesn't slow down. It speeds up. Why does the court's silence matter? Every day the Supreme Court delays, the consequences stack up. It may not seem like much on the surface. A case rescheduled, a decision deferred, but in the real world, lives are impacted. Families are seeing legal bills pile up. Veterans are losing their gun rights over what used to be standard equipment. Prosecutors are digging through old cases, using the uncertainty to press harder. And good people are pleading guilty just to avoid the risk of a felony conviction. This isn't how justice is supposed to work. When the law's unsettled, enforcement should pause. But right now, enforcement is racing ahead. What's really going on behind the curtain? Many legal experts believe the Supreme Court isn't avoiding gun rights cases. They're deliberately waiting for them. But why? The strategy appears to be timing. The court might be holding off until several major cases like Duncan versus Bonta, Oregon's Measure 114 magazine ban, and New Jersey's strict enforcement policies are all in front of them together. That would allow the court to make one unified decision that settles the law nationwide, rather than issuing narrow rulings one at a time. This isn't new. The court did something similar in the past. For example, in McDonald versus Chicago, they waited until the landmark Heller decision firmly established that the Second Amendment protects individual gun rights and then applied that principle to the states. In Bruen, they allowed lower courts to contradict themselves for years before stepping in to set a new standard based on historical tradition. But here's the key difference. The stakes today are far higher. People aren't just debating theory, they're being arrested, prosecuted, threatened with felony records. They're losing jobs, custody rights, even their ability to vote, all because of conflicting laws about what magazines they own and where they live. And the longer the Supreme Court stays silent, the more it looks like they're not being neutral but indecisive. That silence has real costs, and those costs are being paid by everyday Americans right now. The core legal question: what is an arm? At the heart of Duncan and every magazine ban is one crucial question. What counts as an arm under the Second Amendment? The founders didn't say only muskets. They didn't list a round count. They didn't create carve-outs for excessive firepower. In fact, the phrase "shall not be infringed" was meant to stop exactly this kind of erosio, where a right becomes so chipped away by restrictions that it effectively disappears. The court's own decisions, from Heller to Bruen, suggest that magazines are part of commonly used arms. They're essential for modern self-defense. They're not military exclusive. They're not unusual or dangerous in the legal sense. So why are they still being banned? Because lower courts are still using outdated tests, and the Supreme Court, for now, is letting them. When precedent is ignored, one of the most alarming trends in Duncan's story is how openly some courts are resisting Bruen. We've seen lower judges admit they disagree with the new historical standard and then rule based on their own personal beliefs anyway. We've seen state attorneys general instruct police to continue enforcing bans, despite contradictory rulings. That's not how precedent is supposed to work. When the Supreme Court sets a standard, it's binding. But in the world of gun laws, many courts and legislatures are treating those standards as optional, or worse, as obstacles to be sidestepped. Caniglia v. Strom, the Fourth Amendment link. This fight isn't just about the Second Amendment, it intersects with the Fourth. In Caniglia v. Strom, the Supreme Court unanimously ruled that police cannot enter your home and seize firearms without a warrant, even under a so-called community caretaking function. That decision reinforced the idea that constitutional rights don't evaporate during emergencies or public safety claims. Duncan echoes the same tension. Can the government justify taking away something, in this case a magazine, by calling it a danger, even when it's privately owned, lawfully acquired, and constitutionally protected? If the court ruled unanimously in Caniglia that warrantless home entry was unconstitutional, how can it justify letting states criminalize ownership of a common gun accessory? That's why legal scholars see Duncan as a bridge between Bruen and Caniglia. It connects the dots between the right to keep arms and the right to be secure in your property. Where this is headed next. Based on the docket activity, most believe Duncan will be relisted again, possibly for a batch decision alongside similar cases. The court may be preparing to issue one major ruling that sets the standard for all magazine bans nationwide. But until that happens, confusion remains. Some states are doubling down. Others are quietly backing off, and citizens are left guessing what's legal where they live. That's not law, that's chaos. And unless the Supreme Court acts quickly, it risks undermining its own authority and the very Constitution it's sworn to protect. This fight isn't over. This isn't just about magazines or California or one court case. It's about how far the government can go before your rights mean nothing. When laws can change overnight and compliance today becomes a crime tomorrow, we're no longer talking about public safety. We're talking about control. What's happening in Duncan, Oregon, and New Jersey isn't theoretical. It's real. It's personal. And it's putting lawful citizens at risk simply for owning what was once perfectly legal. So stay alert. Know your state's laws. Watch these cases carefully, because what happens in one courtroom can change everything across all 50 states. And if you value real, honest breakdowns like this, no noise, no fear tactics, just the facts, consider subscribing. It helps us keep cutting through the spin, and it makes sure you don't get blindsided by the next legal twist, because this fight isn't over, and you deserve to be ready when it comes to your doorstep.